Court is calling cause number. Can you try again? Never mind. The court is calling cause number 23-PR-14944-B in the guardianship of Michaela Loren Garcia.
Morning, Mark, maybe.
You may. Good morning.
So again, for the record, Daphne had
Mark Stolley for the proposed ward.
Good morning, Mr. Stolley.
Good morning, Judge.
All right. If you'll raise your right hand, please. Do you solemnly swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you. You may proceed.
okay. Can you please state your full name and address for it? That's name and better. And what is your 1024-203 Portland, Texas, Wilmington, 74. And you are the natural mother, the biological mother of Michaela Loren Garcia, is that correct? And Michaela, the daughter, is and she is a permanent resident of St. Pete. And my understanding is that there is not currently a guardianship of her estate in effect right now in any county in Texas or any other state in the United States. And we are applying to have you be appointed the permanent guardian of Michaela's guardianship estate, because there are funds that are going to be due payable to her, is that correct? My understanding is that her father, Renee Garcia, has passed away, correct? And her father, Mr. Garcia, left, for example, what was it, like an investment account or something, payable to her, is that correct? Furthermore, his estate is being probated because she is the sole heir of his estate, correct? And his estate consists of a house and another account, and essentially that my understanding is from that probate case, which is pending in my county on, Michaela will be coming into the money from the sale of the property and the other company had able to his estate, correct? So is that the purposes for which you are applying to be appointed? Because again, the accounts were payable to her or to his estate, and she is consoling. Right? Your Honor, let me ask one question. Do you know of any reason that would disqualify you from the no conviction of a felon, no conviction of a crime in relation to theft, embezzlement, fraud, misappropriation? Thank you. Your Honor, that's all the questions we have for the witness. We also wanted to present this to the court. We received a call yesterday that the guardianship registration has now been, in case the court needs to do this. We completed it. I don't know if that needs to be part of the record or not. I'm happy to make it be part of the record. The applicant here printed out a copy of the registration documents, and I'm happy to present this to the court.
Okay, if you'll just write on there, applicants exhibit 1. How about that? Mr. Stolley, do you have any objection to that?
No, Your Honor.
It's 2 pages as exhibit 1.
Okay, thank you. Mr. Stolley, do you have any questions of this witness?
No, Your Honor. I'm satisfied that the proposed guardian is qualified and not disqualified, that the minor child proposed ward is in need of a guardianship of the estate based on her incapacity as a minor, and that she needs to have a guardian in order to manage her assets. I believe it is in her best interest. I have visited with them at their residence in Portland, and I think she's being well taken care of by her mom. And we have proposed and agreed that my fee would be $750.
Okay.
That's fine. I don't agree.
Okay, all right then, after hearing the testimony, the court finds by clear and convincing evidence that the court has jurisdiction in venue is proper. The court further finds that the proposed ward, Michaela Loren Garcia, is incapacitated due to her age and in need of a guardian with the powers that a guardianship will provide. And the court orders that Ms. Pettis be named as the guardian of the estate of Stephanie Nicole Pettis. And that if you need letters, that letters be issued.
Thank you. Really appreciate it. Do you go upstairs and find the proof in the oath up there?
You will. I think I have, there is a proof of facts here in the file and the oath, and here is the order. So I will sign the order, and I am ordering $750 ad litem fee for Mr. Mark Stolley. All right, thank you, Mr. Stolley. You can get back to your hearing in Nueces County. I appreciate your presence this morning.
I thank you for the appointment and the opportunity to serve the court and the parties.
Yes, sir. Have a good day.
You too, ma'am.
Thank you.
Your Honor, maybe we speak.
The only thing I didn't put on the record is a bond.
Oh, yes, you're right.
That
is true. So right now, as of the issuance of the letters of guardianship, my client, the guardian, will be able to receive $21,000 that's in an investment account, the retirement account that we had at AT&T, it's payable to Michaela in the board. It is true that in some time in the future, and we don't know exactly when, my client is not the administrator of the product estate. So the word may come into some additional money via the product estate in the future. I just don't know how much. All I know is at this time, it's only $21,000 available to the client. In the future, there will be more, but I don't know if that would be right now.
okay.
So the only total court what I know is available now.
All right. I mean, would it be unreasonable to ask for a $5,000 surety bond? Okay, all right. Then the court orders a $5,000 surety bond. And how old is Michaela?
She's 11.
She's 11.
She's in
Okay.
grade at GP.
Okay. Miss Pettis, as she gets older, she's going to pressure you that that's her money. Okay, today is the 23rd.
Good statement.
Yeah,
Kids have a way of doing that.
yes, they do. All right, Ms. Pettis, thank you for your presence here this morning. I'm sorry for your daughter's loss of her dad, and I wish y'all well. You're welcome. Sure.
Should we take that? I'll take that.
Good morning, Alicia. How are you?
Good.
Good. Yes. I put it in the file. I'm sorry. I forgot.
Good morning.
Oh, there she is. Well, hello there.
Hi,
All right,
Judge.
I'll remind y'all, we are in court. This is cause number 12800 in the guardianship of Rodolfo Villarreal. I have appearing by Zoom. If you will identify yourselves, please.
My name is Rosalinda Cedillo. I'm Rodolfo's Villarreal's sister and also guardian.
Okay,
Natalie Cedillo, I am her daughter and Rodolfo's niece.
okay, and Natalie, you are not a part of this case, correct?
No, ma'am, I've just been helping my mother with cake.
I don't know nothing about Zoom.
Okay, no,
Or
I
paperwork.
understand, because I don't either. I have someone who helps me with it as well. All right, so Ms. Cedillo, if you will raise your right hand, please. Do you solemnly swear that the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Ms. Cedillo, I did receive a motion to withdraw as your attorney from Tiffany Fader. Are you aware of that motion?
Yes, she just sent it to me about a week ago.
Okay, and do you have any opposition to the court granting that motion?
No, ma'am.
All right, then I am going to sign the order releasing Ms. Fader from her responsibilities as your attorney moving forward. Okay, Ms. Cedillo, you have been Mr. Villarreal's guardian since 2011, is that correct?
We started it back then, but because of COVID and everything, during the COVID, it took a little bit longer. I think I was granted in 20.
I think 20.
Okay, so part of your responsibilities as a guardian is to file an annual report. And you're aware of that, correct?
Yes, ma'am.
Okay. We did receive an annual report, but there are a few things wrong with it. One is it is not signed, and it is required to be signed. And the other is you did not include an order for the court to approve the report.
Oh,
Okay,
Is that also on your website, Judge?
ma'am, you are not part of this proceeding.
Okay, can she-
I thought I made that clear at the beginning.
I'm so sorry, Judge.
she's taking notes for me.
And
I
that, ma'am, that's fine. But she's not part of this proceeding. She can sit there and take all the notes she wants, but she's going to do it quietly. She's not a witness. She is not part of this proceeding. If y'all were in my courtroom, which you are, you're just in my courtroom via Zoom. But if you were physically in my courtroom, she would be sitting out in the audience quietly. So I'm going to ask that she sit there in your kitchen quietly.
Yep.
Is that understood?
Yes, ma'am.
Okay, thank you very much. So you are required to file a report that is signed, and with that report, you are required to include an order stating that the court approves your report.
Okay.
Okay, so I will give you an extension of 30 days to get that done.
Okay. Where
Okay.
is it?
Today is August 23rd, so I need that filed by September 30th.
Okay,
All right?
got it.
Okay, thank you for your appearance this morning. Get that report in and we will be set.
Where is there that order for the court?
Ma'am, that is not my responsibility to tell you that.
Okay, it's on your website? Maybe.
I don't provide that. That's not my job.
Okay, thank you.
Okay, all right,
Thank you.
thank you very much. Y'all have a good day.
You too.
Yeah. All right, that's what I wasn't sure if who was needed on Zoom. All right, court's calling cause number 11772 in the guardianship of Donald Branson. I have in the courtroom Michael George, and I have on Zoom Mr. Paul Swasina.
Yes, that's correct.
Sir, can you do you have video to show your face?
I'm trying to figure out how to do that on my phone. We were down here at the office.
Okay. All right. Well, that's all right. This is a status hearing.
Yes, sir.
Okay. Well, Mr. George, do you want to go first?
Yes, good.
What is your role in this, Mr. George?
Rather than having me appointed as a dependent administrator subsequent successor, I was appointed as a receiver on about April 11th, 2023, plus or minus. That's when we opened the file. What we have done is locate the property. I've got photographs of the property. It's down Slideville on, I believe, 1224, or it might be 1344.
Okay.
But it's to the right, and it's a few, maybe about an eighth of a mile off of Slideville Road on the left. There is a structure which is depicted in the photograph. The parties have been working on this for, I was told, 18 years. There are some funds that were accounted for. Apparently there's somebody residing on this property. To the best of my knowledge, it is a verbal lease of some sort. We have reached out to the occupant by U.S. certified mail, regular mail, proof of mailing, and then just regular mail, and waiting to hear back from this individual. In the interim, I believe Judge Wellborn ordered whoever is collecting the rent off this property to deposit it into the registry of the court, and she had way back sometime. Jennifer checked this morning with the registry of the court, and there are no dollars in the account with the registry of the court. Now, on Friday, October 13th at 1:30, we've kind of, through Mr. Swastina and myself and some of the other parties, we've kind of been planning like the Hudson Time dash, you know, high school dash, and we've been able to put off the foreclosure for quite some time. However, at last checking with Guaranteed Title Services, there is approximately $45,540.18 due through 2022. The assessed value for their purposes is $187,702. I do not know what the parties' intentions are. It would seem like if they could pass the hat, they can take care of paying those taxes, and that would be one less set of litigators being Plum line barter that we have to deal with. And then there's some issues with, making an accounting as to where the alleged rental fees went. Now, we did reach out in that letter to the unknown occupant. I asked him if he would be interested. It's my understanding he has an informal lease of some sort. Could he fill me in on the terms? It may be at best a month to month. I'm not really sure. We're trying to get this matter resolved. I think that there's some question as to I was told it was an over under 20. Odds are that we can't get it done under 20, and I told them, don't count me out. That I really thought that I could get this squared away. And I'm not sure about if there was an underlying guardianship. But I came in this year merely for the purpose of
Being a
attaching the
paper.
property
Okay.
and trying to liquidate it in order to satisfy, this appears to be the largest creditor. And that's where we are as of today.
Okay,
And I have an avenue to avoid, taking a judgment and then having them issue like a writ. They've been very helpful in working with us, but, we're on 18 years, no pay. But I do have a lender that's willing to work with me. It's in the private sector. In order to pay the taxes, he would assume the first lien position on the property while we sell it. He's perfectly happy as long as he gets his interest rate.
right.
And that's basically where we are this time, to the best of my knowledge.
Okay. Mr. Swasina?
Yes, I have nothing to add to Mr. George other than to compliment him on picking this up and running with it. We had a mediation with Judge Johnson, and as a result of the mediation, there was a Rule 11 agreement that I think has been partially completed, in which there was an agreement to sell the property. So I think that if Mr. George can engage, a real estate agent and circulate, the MSL agreement to the parties to sign off on, we can proceed with a sale. From the sale proceeds, pay off the tax lien, and then whatever money is left over, if any, we can divide amongst the heirs, and also fight about, the rents and everything else that have been collected for years but have not been shared and have not put into the state. So I think that the first and most immediate problem is to compel Mr. Thomas and his client to follow through with Judge Wellborn's previous order, and that is to deposit all of the rentals payments into the registry of the court, and that has not been done now for months and months since it's been ordered.
Okay, so then, what I would like to do, if this works for y'all, I would like to set this for another status on September 20th, if that date works. And I would like to order Mr. Thomas's clients to be present so that they can answer to this question of the rental income. I'd also request, if it hasn't been filed, that a copy of that Rule 11 agreement be filed so that I can see that, and we can discuss that further on the 20th, and get the property listed. If y'all think y'all can get it listed before then, without any court involvement, since you do have a Rule 11 agreement, then, certainly move forward on that. But let's,
Your Honor,
Yes,
the
sir.
only difficulty is I'm going to be gone the month of September.
oh,
I
okay,
am available. I have a Starlink, and I can, I'll be in northern British Columbia, and I can attend a hearing by Starlink. And my client, we didn't find out about this hearing till this morning. My client, Donna Schumann, would normally be present, and she probably will be able to attend on the 20th. My preference is to do it the first part of October when I can be present myself.
right.
But if I need to appear by Zoom, I'm happy to make those arrangements and appear on the 20th. That's what the court would like.
Well, if you're on vacation, I'm not gonna ask that you appear, even if it is by Zoom. How about October 18th?
It's gonna take me a second to check.
No problem.
Oh, if I may,
Yes, sir.
the lawsuit with the taxing authority is October 13th at 1:30.
Mm.
If we could kind of, if,
We need to have it before then.
Mr. Clausina's, the client can accommodate, and his schedule can client, can accommodate earlier in October, I can usually get the funds from the source that I use within 3 days.
Okay, I do have a probate date on October 10th. I didn't see that. That is 3 days before the 13th. Will that work?
The 10th works for me, Your Honor.
Okay. All right, so we're going to set this for October 10th at 9 a.m. And I am going to request that the parties, in addition to the attorneys, be present. If anyone lives, a crazy distance out of town, we can accommodate them with Zoom. I don't know where Mr. Thomas's clients are. But it's certainly, I think it's easier to encourage someone to do the right thing when they're in person. So, but if we need to accommodate by Zoom, we'll do so. So, Mr. Swastino, we will get you a copy of the setting notice, and if you will forward that to your client.
Yeah,
And
absolutely. And I just wanted to confirm that you have my correct address, which is 800 North Shoreline, Suite 2000 North.
800 North Shoreline.
Suite 2000 North,
And what's the zip code?
78401.
Okay, we've got it.
Perfect.
Thank
I will
you.
see you then. Thank you.
Thank you. You're excused. Have a good day.
Thank you. Bye-bye.
Bye.
I think ahead of that hearing, what I'll do is probably file a request to enter into that agreement with the gentleman. He saved me before, and he had to, if he trusts the deals I bring to him, that he will get paid back. And rather than lose the property at a potential foreclosure sale, I'd rather just we don't have to take this.
24 on the south tower. Am I in the wrong or right place?
You're in the right place, but you need to go up one.
I muted him. Oh, I've made the mistake of speaking when I didn't know that other people can hear me. All right, so Mr. George, thank you for being here this morning, and we'll try to get this squared away. This has gone on long enough. I mean, when I see Judge Hatch's handwriting, I'm like,
Sorry.
come on, Judge Hatch.
Oh, that is an old,
Yeah,
that's pre-planning.
yeah, there's 2005, there, his handwriting is here.
Your Honor, I do have a bet with Judge Wellborn that we will not complete this in 20 years. She took the under and I took the over, so you're more than willing to jump in there.
Well,
I could get it sold under 20. I could get it back on the market and liquidated.
I would be happy to pay that bet because we've been trying for quite a while now.
What's gonna be the problem is going to be trying to mess with all these accountings, things that weren't done, and there's appears to be a significant amount of cash that never made it to the register.
I mean, if someone was taking rent for all those years.
Right.
Right.
Yeah, and I'm not sure that several of these parties have gotten sick and are pretty feeble. And my guess is the best that's gonna happen is we're gonna get the property sold, pay off this lien, and that'll be about it.
Okay. All right. Well, thank you very much. Y'all enjoy the rest of your day, and I will see you in October.
Thank you.
Thank you.
Bye-bye.
Can I be excused, Drew?
Yes, sir. You may.